Imagine that police officers come to your door without a search warrant and ask to search inside your residence for evidence of a crime you allegedly committed. You refuse consent, but another person who lives with you, a spouse or roommate, tells the officers that they may search. Would the officers violate the Fourth Amendment by proceeding to search despite your refusal? The United States Supreme Court considered that scenario in Georgia v. Randolph. Officers went to the home of Janet and Scott Randolph after Janet called the police and claimed that Scott intended to take their young son away. The Randolphs had recently separated but were still co-tenants of the home, and they shared custody of their son. Shortly after officers arrived at the home and began to speak with Janet, Scott arrived. He told officers that he had dropped off their child at a neighbor's house to prevent Janet from taking him out of the country, as she recently had done. Janet then claimed that Scott was a cocaine user and said that evidence of his illegal drug use was inside the home. When one of the officers asked permission to search the home, Scott unequivocally refused. The officer then turned to Janet and asked for her permission. She told the officers they could proceed with the search. The officers searched inside the home and recovered a straw with cocaine on it from Scott's bedroom. Scott was arrested and charged with possession of cocaine in state court. In a pretrial motion to suppress the cocaine, Scott contended that the officers engaged in an unconstitutional warrantless search by entering the home after he had refused consent. The trial court denied the motion after concluding that Janet's consent was sufficient to authorize the search. Scott filed an interlocutory pretrial appeal to the Georgia Court of Appeals, which reversed the trial court's order. The state then appealed to the Georgia Supreme Court, which affirmed the judgment of the Court of Appeals.